A lot of his criminal offenses, the domestic violence, misdemeanors, plus his history with the municipal courts, plus prior felonies, all drug related. This case was drug and alcohol, not alcohol related, just drug related. In this case, he was parked. He had been with his friend. They were working, and he had smoked some marijuana that day.
He thought it was glue. All right, this is Evan's fault, and also there's a channel on here. I'll figure it out. Before to shut them out later, and then Zach. All this is from Ohio for some reason. I don't know why. It's Ohio Sunday.
And prior to that, he had used.
This is Minecraft, but the channel I took it from, it looks like they mirrored it, so it's weird because whatever, it's mirrored. It's the image is flipped.
Meth much before this. He pulled over because he was tired. He was sleeping in his car. The officers came up. They opened the door because he was sleeping to check on him, and then he spoke to the officers. And he didn't give them a hard time, but as we talked about, he wasn't necessarily cooperative, doing exactly what they wanted, giving him everything, but he was not rude or aggressive against the officers. And they told him that this was a felony OVI, which he knew it was not. They told him they were going to get his sample anyways, so he gave them a sample so they could have that, and it shows that he's over the limit for marijuana as well as methamphetamines. And when they initially opened the car door and they saw his wallet, he had a small pack of drugs. It had meth and heroin, or fentanyl, I'm sorry, on top of his wallet. The officers immediately saw that, and he gave it to the officers. As such, he was in custody. Your Honor, with his history, we could send him to prison for the 12 months, but I don't think that would benefit.
Just a small bag of fentanyl, where you can get the whole county high with a thimble. Okay.
Anybody except keeping him away, and the cost of that. He's been sober here in the Lake County Jail since May 28th.
Good work.
Lake County Jail has a very good track record of keeping drugs out, though nothing's 100%. But in prison, we know that he has access to drugs, and we'd like to maintain his sobriety. He's got a nice start going now. He wants to be drug-free. We did talk about his employment, and if he could be a welder, his life would be different, but he's had some other issues. So we'd ask the court for a 6 or 7 month sentence. His mother is sick. That way he would be able to rejoin his family. He doesn't want to live with her because she drives him crazy, but that's still his mom. So he would like to be able to be there for her. And if he spends most of his time here in the Lake County Jail, we could almost guarantee his sobriety. That way he has a good base to start. When he goes to prison, they'll evaluate him for PRC, and it's unlikely, given an F5, that he would receive that. But his history, they may decide that. So we'd ask the court for a 1-year license suspension, 10 days mandatory jail, mandatory fine as per the OVI, and then for the court to order 7 months prison with credit for time served.
Okay,
Michael?
what do you want to tell me?
Yes, I take responsibility for what I did. I'd say this time is probably the best I've done since I've came home from prison. And if I got my license back, I got a car, motorcycle. I relapsed when I first came home from prison. My family helped me go to treatment down in Texas, which I completed. I came back here when my mother got sick. That's why I came back to Ohio. She had brain surgery. So I came back here. My brother passed away. I was enrolled into the methadone clinic for almost a year. I had a sponsor. I went to 3 to 5 AA meetings. When we had his celebration of life, I started hanging out with some of my old friends. I ended up going out for New Year's Eve, and on the 8th, I was back in jail. So I know what I did wrong. I realized what I did wrong. I take responsibility for what I did. I don't know. I know it's up to you. I just want to do whatever I got to do to get back to my mother as soon as possible. If that's, if I have to go to prison, I hope I don't have to go back to prison. But, I would hope that I could just do the time and be done. That way I'm able to leave the state. I also work with my father, too, to go out of town a lot. So that's one of the things. If I was on probation, it's kind of hard for me to leave the state. I plan to go back to Texas after my mother's health gets better. And that's it. Thank you.
State of Ohio, and trust the court to pass in a sentence that's appropriate in this matter. Thank you.
Why are you in jail right now?
Why am I in jail?
Yeah.
Because I was on house arrest. I bonded out, and I didn't do the house arrest. Me and my mom were arguing. Well, my brother just passed away, and it was hard for me to sit there. She was just screaming and crying all night. And my house, I had a girlfriend I broke up with, so I was kind of in the middle of where I could go, and I tried to contact the court, and it was in the middle of being bonded over. So they said to contact here. By that time, I already had a warrant.
A warrant out of Willoughby?
No, came out of probation, I believe. I was out 10 days when I bonded out.
Well, I don't know where the warrant came out of because this was bound over. I don't know when it was bound
Well, it
over.
was
There was
supposed
an
to stay
information that
misdemeanor
was filed
for
on
a
September
while.
11th, so I don't
Yeah.
know where the warrant came from, but.
It had to be from Muni because it came over to me as a bond revoke.
That's when I was
Yeah.
in the hospital. And
All right, so
I had the court.
what do you do for work?
Well, my dad owns a commercial diving company, which he's semi-retired, so I help him when he needs help. I'm kind of in the middle of starting up a mobile tinning and like doing car wraps, and then I've been doing like pressure washing like houses and residential and commercial stuff like driveways, siding, stuff like that. Been trying to get started. My dad's been helping me with that.
What's with this theft out of Menor?
That was me being stupid, and I guess I don't
Why
know
are
what
you being stupid?
I wasn't thinking. I made a bad mistake. I picked
Why-
the pocket
why?
knife up, and instead of paying for it,
Why are you being stupid? It's such a great O'Donnell question.
I didn't pay for it. I had money in my pocket. I don't know what I was thinking. I shouldn't.
Well, were you high at the time?
Yep. That's when I relapsed.
Okay. When was that charge?
I was out on bond for this charge.
Right.
I think it may have happened right before this happened. No, I got this and then that happened right after it.
How long have you been working for your dad or with your dad?
About 20 years.
What did your brother die from?
He had a bleeding ulcer, and he ended up like almost drowning to death, and he fell backwards and hit his head.
Why have you spent the last 20 years or more squandering your opportunities?
Drugs and alcohol.
Why?
Because a lot of it, I guess, I would just I wouldn't say depression or whatever, but I would just drink and use alcohol to try to forget my problems, I guess.
What problems?
I guess missed opportunities, stuff that I should have done a long time ago. Arguing and fighting with my son's mother. I haven't been part of my son's life until I came home this time. I actually got a good relationship with my family. My mom actually wanted me there to come back. This is the longest I've been sober. I was sober 16 months.
Yeah, it sounds awesome. You're just saying that your mom was crying and screaming and you couldn't deal with her. Literally a minute ago.
It's the longest I've ever been sober.
Okay, so you went to treatment in Texas.
My
right?
family gave me $50,000 to go down there.
How long were you down there?
I was down there for about 5 months, and then I went to sober living for 2 months, and then my mom got sick.
Okay, and so you were down there in sober living?
After I completed treatment,
Right.
yes.
So when did you come back here?
I came back here about January of last year. I was home for about a year and a half.
And so what were you doing in the course of that year?
I was going to the methadone clinic. I was going to 3 to 5 AA meetings. I had a sponsor, a home group. I was working, got my license.
Where is a methadone clinic?
In Menor. It's
Where-
new season. Right across from, is that Heinen's? Yeah, Heinen's. And they're right next to McDonald's.
And why do you take methadone?
Because I was on Suboxone when I came back here, but I couldn't get into anywhere that had it. That was the easiest place for me to get into.
What does methadone do for you?
It kept me, I didn't have any cravings to get high. Plus it if I took methadone, if you get high, it makes you sick. So it kind of deterred me from it. I didn't have any cravings.
Then why did you have meth on January 9th or 8th?
Because when I went out New Year's Eve and I drank and I was around my old friends, I was back around it and I ended up doing it then.
What old friends?
Friends that I went to high school with, friends that me and my brother grew up with that during his funeral. And so that's why I was back around them. And instead of me calling my sponsor or hanging out, I quit going to much meetings as I was going to. And next thing you know, I was hanging out with my old friends and
You never saw that coming, right?
not until it was kind of too late. Now I know where I messed up
Well,
now.
So when did you start drinking then? In
New
relation
Year's
to
Eve. I
New
relapsed
Year's
New
Eve?
Year's Eve.
Oh, we know where you messed up. It's not a mystery.
And I was here on the 8th.
Okay. So you said 16 months you were sober?
Mm-hmm.
Okay. So for 16 months, you knew exactly what you had to do to be sober every day.
I stayed away from those old friends. As soon as I got around
Why did
them,
you stay away from the old friends?
that's what I was told what to do.
Okay. Did it work?
I don't know. I'm no expert on the topic, but are you sober if you go to the methadone clinic? I don't think it counts.
Okay. So why did you change that?
Because I was around them for my brother's funeral and I made a poor decision to go out New Year's Eve. I thought I was okay. I thought I could say no,
What went into your thinking when you went out on New Year's Eve?
that I wouldn't drink.
Where were you planning to go New Year's Eve?
We went out to, to my friend's house, and then we ended up going to a restaurant and a bar, which I should have probably not went to. I thought I was strong enough to say no until I was there.
Why would you think that if you've been doing drugs for 20 plus years? Why would you think you were strong enough?
Because I've been in restaurants and stuff like that and haven't drank or been around it before, and I don't know what made me change my mind that night. I decided to drink. I don't know. I guess I was feeling sorry for myself, feeling sorry, about my brother. I made a poor decision. It led me back here.
Okay, so you drank on New Year's Eve. Did you do any drugs on New Year's Eve?
Mm-hmm.
What?
Meth.
How
That's why I still had it.
Oh, come on now. Come on.
If I was under the influence of meth, I wouldn't have been sleeping.
Okay. The- what were you under the influence of?
I wasn't under the influence when they arrested me. I was tired. I worked 10 hours.
What did the results show on the?
It was
170
marijuana and methamphetamine, Your Honor.
171 nanograms per milliliter for marijuana.
Why were you doing marijuana?
I have a medical card.
So what? What? If you're a drug addict, why would you take a drug?
I love it. I love it. I can't believe he said it. So what? Nobody cares. Nobody cares that you bamboozled the doctor into giving you a prescription for marijuana. We're not impressed. It doesn't mean you need it.
Why do you have a medical? Where did you get a medical marijuana card?
I've had it for about 2 years.
Where did you get it?
From the doctor.
What doctor?
I don't know his name exactly.
Where is he located?
I got it from Cleveland.
Well, where?
And then
in
I
Cleveland?
did it because it was during COVID. So I did it Zoom.
Well, you said you had it for 2 years. This isn't during COVID.
Well, it was right when I came home from prison I got it. It was at the end of COVID.
Where did you go to see a doctor in Cleveland?
I did it online.
You
And
did
then
it online. So you go online. What did you tell this witch doctor online?
they asked me if I had PTSD or if I had anxiety.
What did you tell them?
Yes.
Witch doctor for the win.
And then what was the follow-up question to that from the doctor?
There wasn't very much that they asked you.
How much did you pay for that?
It was like $300 for the consultation, and then you had to pay a $50 state fee.
What a joke. So this guy's not a doctor, he's a quack. He's a quack on a phone. And I don't understand, I don't understand you. Why you take an opportunity that you had. As I understand your father's business, it's a hell of a business.
Yes, sir.
So I can't understand why a guy like you with the opportunities you've had, just says, piss on it, I'm gonna do whatever I wanna do. I don't understand how a drug addict, a lifetime drug addict, thinks that taking an addictive drug is a good idea. Now, when you told the quack on the telephone for $300 that you had PTSD, what did you have PTSD from?
My friend died in the room next to me
Okay, when?
about 7 years ago.
Okay, and how is your PTSD exhibited?
I mean, there'll be times where I just wake up and feels like my heart's about to jump out of my chest, anxiety.
Did you
sometimes
seek any like psychological counseling?
Yeah, they were giving
God
me.
damn, everybody's got PT. I got PTSD from sitting here listening to this shit. Okay? Why does a drug addict seek out drugs? Medical marijuana. What a dumb idea. Suboxone, an addictive drug. What a dumb idea. Methadone, dumb idea.
Well, now I'm off of it. Before it was.
Well, you're off of it because you're in jail.
Well, they would have gave it to me in jail, but I really didn't want.
I have no knowledge of that, okay? If
Yeah.
they're doing that,
Yeah,
then
they give you-
that's another problem growing out of today.
They give you methadone and Suboxone in jail now.
Jesus Christ. More and better drugs. Brought to you by the American pharmaceutical industry. The only way you're going to stop being a drug addict is to stop being a drug addict. The only way you're going to stop taking drugs is to stop taking drugs. Now, you can find a million excuses. Your brother, your mother, problems with your father, your friend dying, your dog dying in 1984, whatever it is, okay? You can find a million excuses. They're out there, okay? And you're either going to not give in to those excuses, or you're going to give in to those excuses. So far, you've decided you want to give in to the excuses. Because from what you're telling me, if it's true, 16 months you're sober. You're not really sober because you're taking drugs that doctors are feeding you, okay, so-called doctors. New Seasons. Sounds nice. Doesn't that sound like a nice place, Tim? New Seasons? Who wouldn't want to go to New Seasons? Who doesn't like New Seasons? Renewal. Great idea. Stupid idea. So if you or your father spent $50,000 on treatment, what good did it do?
Well, I wanted to change too. I wanted something different.
Okay, so why didn't you do something different?
I don't think I had the mindset before. I really didn't care before.
Why not?
I don't really have an answer for that. I was doing drugs, so I'd never really
Why
had a
don't
clear
you spend
mind.
your time finding the answer instead of ignoring the question?
Well, I think this time I did. I worked on myself instead of worrying about everything else or everybody
Well,
else.
in the end, what good did it do? Because you went right back to it. What good did it do? You know why it didn't work? Do you know why it didn't work?
I didn't keep doing what I was supposed to
Because
do.
you didn't put the effort in to make it work. Your problem is the lack of effort and the lack of resolve that only you can solve. All right, I've read the pre-sentence report. I've considered what you said and what Mr. Deeb has said, what Mr. Geigerich has said. So you're not amenable to community control. You're going to serve a sentence of 8 months in prison on count 1 with credit for 150 days. On count 2, 150 days in the jail with credit for 150. 2-year license suspension retroactive to January 9th. 24, 575. Is that the minimum on this?
I do
Fine,
believe so.
575.
Confirm that, I do have the cheat sheet.
Huh? Well, whatever the minimum fine is, I think it's $575. And the costs, are there any other penalties on this OVI that are mandatory?
I don't think so, Your Honor. I think you got the license suspension, you got the fine and the days.
I believe it's 525.
$525.
Is that what you want, 525 then?
$525. And then when you're done with your sentence, you might be on post-release control for up to 2 years with conditions. If you violate parole authority, who doesn't do anything as a matter of course, could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If it's a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months of the time left under post-release control. You're 39?
Correct.
Okay. I guess you need to figure out how you want to live what, under normal circumstances, is probably another 40 years of life. Anything else, Mr. Geigerich?
Nothing, Your Honor.
What's the
Thank you.
jail credit, Judge?
What?
Jail credit? What was it?
150.
He gave him 150 days.
150?
And forfeiture of the contraband.
I'm Judge David Landenfeld. I'm a retired judge sitting by assignment of the Ohio Supreme Court. And this is the matter of the state of Ohio versus Philip Cook. It's case number 24 CRB 781. You're Mr. Cook, correct?
I am.
Mr. Cook. I don't know if you're represented or not by Attorney Warren in Morford Jr. Good morning, Mr. Morford. You are present here, and it's your understanding that you are representing Mr. Cook. Is that correct?
That's correct, Judge. I've never been relieved by this court of my duties to Mr. Cook, although I'm going to ask you to do that when the time is right.
All right. And representing the state is Special Prosecutor Ryan Q. Ashworth. Good morning, Mr. Ashworth.
Good morning, sir. Thank you.
And let me clear up a few things first. On October the 28th, Mr. Ashworth, you filed basically a nolle prosequi with respect to count 1 of the complaint. That is the theft charge. Is that correct?
Yes, sir, I did.
And your basis for doing that is?
After review and preparation for this hearing and looking at the current status of the law, I did not feel like it was appropriate to bring that charge under a variety of new cases that has come out. I didn't feel like it was the appropriate charge for the facts as I reviewed them after interviewing the witnesses and preparing for what I believe to be the trial. I believe that the charge should have reflected a disorderly conduct. And so the second motion I filed on the 29th or the 28th, I believe, was a motion to amend count 2 from the trespass charge, which is an M4, down to the disorderly conduct charge, which is a minor misdemeanor.
Very well. The court has granted your motion to dismiss the first count in this matter. Furthermore, the court has granted your motion to amend count 2 from the charge of criminal trespass to one of disorderly conduct. I believe that's under section 2917.11A1 of the revised code, a minor misdemeanor.
I haven't even seen this courtroom before. Zach sent this to me. We'll see.
In addition, you filed a position statement, Mr. Ashworth, on October the 29th of this year, whereby you indicated that it appeared from filings made by Mr. Cook that he's engaging in hybrid representation, which is prohibited in the state of Ohio. Is that correct?
Yes, Your Honor, and the fourth district just ruled on this at the end of May of this year in State versus Lucas, cited in my position statement. Anything that was done by the defendant as a pro se or in the ostensibly as a pro se defendant, when he has counsel of record that has not signed off on the motion, whether he calls it hybrid representation or not, it is effectively by the actions that he had taken, hybrid representation by the case law, and therefore invalid. And I asked the court to void all of those filings ab initio as though they didn't exist and were never had.
The court finds that position well taken. Indeed, it follows the Ohio Supreme Court's ruling in State v. Martin, which is 103 Ohio State 3rd 385. So the fact is, any of those filings, and I've made an order, I've entered an order to that effect.
Judge, may I be heard on that point?
No,
Okay.
because you were represented by counsel at that point, Mr. Cook, and the fact is, you're not permitted to have representation and represent yourself. We call that pro se representation. That is essentially a hybrid representation, and that is not permitted. So based on that, the court did enter an order that all your pro se filings, which are not signed by Mr. Morford, or which do not seek to confirm a knowing, intelligent, voluntary waiver of counsel in open court, are null and void ab initio. That's the order of this court. Now, at this point, Mr. Cook, because the court has ruled that count one is dismissed, the theft charge is dismissed, and because there has been an amendment to count two, making it a minor misdemeanor, at this point, you're not entitled to court-appointed representation. You understand that?
I do understand that, but I think that the facts underlying what Your Honor just ruled to are, there's some information that you're unaware of.
Well, I don't know what you could present that would change my mind.
Oh, may I?
Have at it.
Judge, on, let me get the exact date. I have sent my attorney, and I have all my emails here that I can produce, notification that I was setting him second chair.
You
Because,
didn't say that in open court to the judge.
I'm sorry,
You did not say that in open court to the judge.
I was unaware that I needed to do so. However,
Okay, that kind of ends it right there, Mr. Cook.
okay,
So I take it, Mr. Morford, based on the fact that Mr. Cook is not entitled to court-appointed representation, you would like to be relieved of any obligation to represent him, is that correct?
Absolutely not.
Very well. Mr. Cook, because there's no incarceration to be associated with the charge as it stands at this point, the court is going to allow withdrawal of representation by Mr. Morford, and we can proceed on this as a minor misdemeanor. It'll be a trial to the court unless there's a resolution.
Judge, if I may, I would prefer, if you would allow me, I have audio recordings and video recordings of Mr. Morford lying to me, hiding documentation from me, lying about the existence of documentation, violating numerous ethical rules that are set forth by the state of Ohio. I have audio recordings of phone calls that I had with him. And Mr. Morford brought up the fact that he was never given the opportunity to consent to the recordings. However, Ohio is a one-party state when it comes to recording phone conversations. So long as one party to the conversation is aware that the recording is being made, the recording is legal and lawful. In addition, Judge,
Objection, Your Honor. This is completely irrelevant.
Listen, Mr. Cook, what's this have to do with the charge against you?
It has to do with why Mr. Morford is being relieved, Judge.
No, he's being relieved because the charge against you now is a minor misdemeanor. It carries with it a penalty of up to $150 in court costs. Now, how you deal with that is going to be up to you. You may hire your own attorney, retain your own attorney if that's what you wish to do. But this court has allowed Mr. Morford to withdraw. And in fact, there's no basis for him to be your attorney in this matter at this point, because there's no incarceration that could possibly come about if you are convicted of the charge of disorderly conduct.
Okay,
Do you understand that?
I do.
Okay. Mr. Morford, you are excused if you wish to be.
Thank you. I'm going to move to the gallery, Your Honor.
Very well.
Thank you.
Now, with the new charge,
Oh, Your Honor, if I may, before you proceed, may I request any and all documents that were produced by Mr. Morford, any evidence that's in his possession, such as videos, any of that be sent to me so that I can have a full account of what he has, because there's documentation that he has not sent to me.
Judge, for the record, I've provided Mr. Cook with everything that I've received from the state of Ohio in response to discovery answers.
and that's pursuant to Criminal Rule 16?
Yes, Your Honor.
Okay.
Except, Judge, the fact is that he has made filings in this case, specifically answers to motions that I had presented, that I have not been privy to.
Judge, if he wants to give me a written demand setting forth what he is asking for, I'll be happy to try to comply with that if it's appropriate.
That's fine. Technically, Mr. Morford's no longer on the case. You have the whatever information he has that he can provide to you, he's indicated he will provide. So I don't see any prejudice to you at this point.
Okay.
All right. So,
Judge, one other issue I'd like to bring up momentarily. Are you aware that there is at least one fact witness in the courtroom at this time as a member of the court?
and what's the relevance of that, Mr. Cook?
Well, I think that in the concept of a fair trial under the Eighth Amendment, Judge, persons who are,
Under the Eighth Amendment?
I'm sorry,
You're not an attorney, are you, Mr. Cook?
no, Judge, but I
Okay. Look, we'll be happy to give you a trial in this matter, a fair trial. I don't know.
Look, you're stupid. You're embarrassing yourself. You don't know what you're saying. It's sad. Stop.
What additional information, or it's not even information, but what discovery you need to try this case. But that's something the court is, Mr. Ashworth, have you provided all discovery in this matter, is that correct?
Your Honor, actually, before I was assigned to this case, discovery was had between the state and the defendant in its entirety. And there's been nothing new that he doesn't have. However, I will represent to the court that I will go through and vet anything that he doesn't have and he can have it. I have nothing that I'm going to keep back from him.
need a copy of the video surveillance, Judge.
I don't have that. And if I don't have it, then I can't make it appear for him. So that's a different issue.
I know Mr. Morford's in possession of that video surveillance, Judge.
I'm sorry?
I know that Mr. Morford is in fact in possession of that video surveillance.
Well, then I would demand it then.
All right. Well, at this point, are there any motions that you're going to wish to file? Or first of all, are you going to retain an attorney to represent you in this matter, Mr. Cook?
I have not yet decided, Judge, but I am going to request.
Well, we need to decide that, because you're either going to represent yourself, that is, you're going to be a pro se defendant, or you're going to retain your own counsel who will serve as your representative. It's either or here.
I'm aware of that, Judge, but given the fact that this was just dropped on me 5 minutes ago, I would request from the court maybe a day or two to make a decision on how I want to proceed. In addition, Judge, I believe that there are fruitful conversations that can take place between myself and the prosecuting attorney once he actually receives the video surveillance.
I'm more than willing to have, I actually tried to introduce myself to him earlier today and he wouldn't shake my hand.
Okay.
But it doesn't hurt my feelings. I'll be happy to work with him through anything that he wants to work through. I am not, sir, I'm a special prosecutor. I am not the prosecuting attorney's office, and I don't have any vested interest in you winning or losing your case, just making sure that it's appropriately set forth before the court. That's all I care about.
Well, and I'll say that I respect that position. The reason that I refuse to shake his hand, I want the court to hear this, is because of the filings that he made yesterday. Okay? He made these filings without having all the information, specifically the video surveillance in hand. The video surveillance, I believe, will dramatically impact his filings, especially his special project fund. Not only that,
I'm taking that under advisement. I don't know that this court, or at least I, as a visiting judge here, have any authority to set up a special project fund for this case. I don't know that it could be done retroactively if it were set up. So I don't know. I'm taking that matter under advisement. If you want to file something in response to his motion, feel free to do so.
well, and the other thing I'd like to bring up, Judge, is the other motion he made yesterday, the special statement. That was made in the 11th hour. I just received it yesterday. It was just filed. I haven't had a chance to fully review and look through the law as that statement. It's, you know.
Oh, I'm sorry. You're talking about the special project funds?
No, the special statement,
Your position statement.
position statement, that's the one.
That's settled law, Your Honor. I appreciate what he's saying. I would honestly, the fact that I submitted it early was a courtesy. I was just bring it up in court today and make the same movements here. So I gave you an extra day,
Well, and
but it's settled law. Feel free to review it. I'm not trying to hide the ball here.
one thing I'm trying to convey to the court and to Mr. Ashworth is once he actually views the video surveillance, that may severely impact his.
No, it won't, Mr. Cook, and I'll tell you why. What you did by making those files while represented by Mr. Morford violates Ohio law. It's not a criminal offense, but you're not entitled to hybrid representation in the state of Ohio. In fact, I don't think you are under the U.S. Supreme Court rulings entitled to hybrid representation. You may represent yourself and maybe have an attorney who is sitting to advise you, but not representing you. Or you can have an attorney represent you, but you can't combine the two where you're filing documents while you're represented, okay, without the approval of your attorney. So you may not appreciate it, you may not like it, but that's the law. And that this court's going to follow.
Well, Judge, if I may, given the fact that those filings were not accepted, I'd like to resubmit them at this time for consideration.
Resubmit which ones?
All of the filings that all the discovery requests that I made, and I'm going to have an additional discovery request, Judge.
Look, on August 27th, you filed a letter of intent to sue. You want to refile that?
I didn't file that, Judge,
It's signed by you.
but it was not filed by me, Judge. That was emailed to Mr. Morford, not for filing, for his own information,
Well, it got filed.
without my instruction, without my request. And I had,
Why don't you decide what filings you want to make that are relevant to the case as it's now existing? It's existing as a minor misdemeanor, disorderly conduct.
I'm aware of that. And this case bumps right up against the First Amendment's protection of free speech and right to redress grievances with your government.
Well, I disagree. By the way, Your Honor, everything that he's filed up to this point is void. It's not, he can't resubmit it because it was submitted improperly to begin with. He has to recreate it and file it appropriately under the rules. It has to be a new filing signed by him while Mr. Morford is no longer counsel of record. And that's what I'd ask that he do appropriately.
Then I request leave to do that, maybe 48 hours to resubmit those filings.
You can have weeks, Your Honor. There's no timeline for it.
There's no time. I do want to get this matter resolved for everybody.
So do I, Judge.
Okay. And I don't know what to tell you. I'm not going to give you legal advice, but the advice I am going to give you is that anything you want filed
Where's
now,
my
you're going
card?
to have
It's
to
gonna have one.
recreate and submit. I want you to submit it either by, do you take email filings here?
If we can, but not criminal matters.
Not criminal matters, so you'll have to mail those in. I have concerns only because of representations that have been made to the court regarding what's, things that have occurred here. And I don't want to have any other incidents or alleged incidents happening.
Judge, I can offer this court a third option.
What's that?
The last 2 times that I was here to file documents, I audio and video recorded those filings, okay? It captures the entire conversation. Through that conversation, I was perfectly polite and courteous with the clerk staff. I will offer that if I have to come here to make filings, I will audio and video record those with my phone, okay?
Objection, Your Honor. That doesn't protect the people here that I'm trying to help.
No,
They're scared and worried.
Let's make your filings via mail. You can do it via mail, via FedEx, UPS. You can do it some way other than appearing in person, because I know the staff here feels uncomfortable with you being in person, unaccompanied.
Here's the thing. Everyone thinks you're an a-hole. You earned it. Mail your filings in.
So let's do it that way.
Then what if one of the bailiffs escorts me to the clerk's office?
Mr. Ashworth, what's your position on that?
Well, I certainly don't profess to understand the logistics of the staffing here, but my understanding is sometimes that's not available, Your Honor.
I can make a phone call and prearrange to come in and make the filings.
I would have to talk to the victims before I could commit to that, Your Honor, because some of these people are really, truly worried and scared.
Okay, then what we'll do, let's see if we can get a way to allow you to file things. Certainly, you can always file by mail or UPS or FedEx or some delivery that way. It's not, I'm speaking.
My apologies.
Let me speak.
My apologies.
Please. And we'll do it that way unless we can come up with a different scenario for it, because I want everyone safe. I want everyone to feel safe and feel secure here at the courthouse. And that includes you. Okay?
May I say something?
Yeah.
Judge, I want the same thing. I want everybody to feel safe. Spent 9.5 years in the Army and deployed numerous times to Afghanistan to defend this. I don't want anybody to feel unsafe at all for any reason. And I have no intention, nor have I done anything, and this will be reflected with the surveillance video, to cause anybody any kind of fear.
Well,
And
I think there's some people here who might disagree with that. And I don't want, I don't want to cause
Here's the problem.
Behavior in this case is disgusting.
any more issues than already may exist. So, and there may be no issue here. I don't know. You stand right there as a citizen accused of disorderly conduct. You may want to speak to Mr. Ashworth about a resolution here. I don't know if that's possible. If not, we'll set this matter for trial. Within the next 10 days, if you could file any requests for discovery, and it has to be in accordance with Criminal Rule 16. I'm going to hold you to those rules if you're representing yourself, or if you retain an attorney, then the attorney can do it on your behalf. Okay?
I'm gonna let the court know that I'm going to reach out to the Southeast Ohio Legal Center, which does pro se representation for indigent persons, which I fall in that category. I also have some other.
Is that like a legit thing? I mean, it could be some public interest thing. I don't know. But he thinks he's got him. He thinks he's got him on the ropes now. I'm going to contact some attorneys who don't have, busy enough practices that they mess around with this crap. Oh, well, we're all shaking in our boots.
Avenues that I'm going to explore. However, in good faith, Judge, I'm going to submit these motions for discovery within, today's Thursday, so hopefully no later than Monday. Okay. However, I do ask that if the court is going to require me to mail them, that the court offer a little bit of a buffer there, because nobody can control the mail.
Well, I'm fully aware. I'll tell you what, can you get it in by November 17th, any of your motions?
I don't see a reason why not, Judge.
Okay, let's make it, unless you have retained an attorney to represent you, that you'll file any motions that are pursuant to the criminal rules. I've said discovery is Rule 16. That's only one of a whole bunch of rules. So
send it certified mail and track it, dummy. At least then you have proof that you sent it. It's all irrelevant and wrong and stupid, I'm sure. But that's how you do it.
let's do that. Get that filed no later than November 17th. All right?
That's fine, Judge.
Is there anything further we can do here today, Mr. Ashworth?
To the extent we can, I would somewhat prefer to go ahead and set the trial date, but that's completely at the discretion of the court. If we haven't addressed that, I assume we don't want to broach that yet. So that would be the only thing I would have.
Is there, assuming that you can respond to the discovery and we don't have a problem, can we set this for trial maybe December 15th? Is that, are Mondays good, or what's a good
Mondays are
day?
not good.
Okay, what's a good day that week?
I would say a Wednesday or a Thursday.
How about Wednesday, December 17th?
That might be what's going on. Does this knucklehead have a channel? Because if he does, it sucks. Might be some free material over there.
Does that work?
That should be fine.
May I have a moment, Your Honor?
I don't have anything on that day.
Okay. I should look and see if I have anything. It's not gonna be a trial without me.
Your Honor, on behalf of the state, that date's fine with me.
Okay, let's make it December 17th. Let's do it at 11 o'clock.
Robert, on the deadline for the defendant, is that to file any motions for discovery?
Any motions or motions for discovery? Yeah, any type of motion.
I would like the right, Your Honor, to have that same opportunity, because it sounds like they've got some things that I don't have.
Okay, that'll be fine. We'll both have that.
And that was at 11 o'clock, Judge?
11 o'clock, yes. All right, if there's nothing further, I am taking that motion. If you'd like to respond to the motion, Mr. Cook, that Mr. Ashworth filed regarding the motion for designating a case-specific special project under revised code 1901.26B1, you may do so.
I would like to discuss that, Judge. And I haven't.
Why don't you file a response rather than, unless you want to argue it orally, Mr. Ashworth?
I think it would be most appropriate for the defendant to have an opportunity to review it and file some written stance on it, at which time I will take his research under advisement and then tell the court whether I'm going to continue to pursue it, potentially withdraw it, or ask for oral argument on it.
Okay, why don't you
If I
do that by the 17th?
In short, I'd like to do the usual. I'd like to do the usual thing that we would do if everyone was normal and rational.
I can. If I do have a couple of issues that I'd like to bring up now, if it's okay, because it relies on his special project fund relies on a couple of assumptions that he's made without having all the evidence, and I can take less than a minute to address the issues that I have.
Well, look, I know I've read his motion. That what I have more of a concern about is don't worry about the factual background. Worry more about whether under the Ohio Revised Code and under any case law that I, as a visiting judge, or such as a fund could be applied retroactively in this case.
There's one factual thing that he's not aware of that I'd like to make him aware of, that this relies on.
What is that?
It relies on the fact that I made the motion to disqualify the prosecutor's office. Okay. The fact of the matter is, if he takes time to review the hearings where that motion was made, Mr. Heald was the originator of the idea for the prosecutor to recuse himself for a conflict of interest. That was not my idea. That was
Okay, who cares? We've got a special prosecutor. That's where we are. So what? How that came about is effing irrelevant. Here we are with the special prosecutor.
an idea initially proffered by Mr. Philip Heald, who was in fact the prosecutor at that time. I only brought it up in court because nobody else did.
I'm going to caution the defendant, Your Honor, if he continues to discuss these conversations between him and his prior counsel, I'm going to ask the court to lift the privilege and let me interview prior defense counsel.
That's going over his head. At least he doesn't say recruits. I'll give him that.
Mr. Cook?
I'm just discussing things that were discussed in open court. This was all discussed in open court, Judge. None of this is privileged.
Well, okay, none of it that is privileged between you and Mr. Morford. The court is going to allow you, Mr. Ashworth, to speak with him regarding disqualification, or it's not disqualification, but the request to have a special prosecutor here. Okay?
Judge, that was all done on the record, and I don't know what additionally my attorney could proffer because everything was brought before the court.
All right. I think you should allow them, Mr. Ashworth, the opportunity to make certain that that was everyone's understanding, all right?
That's fine.
Okay. Is there anything further we can do here? I hear nothing, then we are adjourned.
Thank you, Your Honor.
That was fun. Thank you, Zach. Good times. Good times. You know, all that talk of recusing makes me want to hear some moat point. I'll take you out with this and send you over to Biggin.
Yo, turn the beat up in Vaughn's dictionary. We ain't spelling right tonight. Nah, we spelling wrong. Step in the courtroom. Words all twisted. Sherrick Vaughn speaking like logic got evicted. Mirandarization, boy, that ain't a word. Whole jury laughing like, what did we just heard? Unlogical motions, compelment too. He reiterate nonsense like deja vu. Try to squash, not quash his own case in flames. Even spell check filed the motion saying, bruh, that's lame. It's a moot point, baby, sinking in the trial. Sherrick Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew. But the only thing recused was his brain from the view. Dixon, Tennessee, home of bad boy blunders. Vaughn taking L's like it's courtroom thunder. Fire